Tom Lambert, who wishes to speak, supporting the bills from Michigan Open Carry. Tom, if you come on up, you have the floor, sir.
Members of the committee, thank you for your time. Thank you for being willing to hear what the committee was afraid to hear 2 years ago. I want to be very clear. This we're talking about today is not a question of whether we handle certain individuals. Today's question is how do we handle those individuals? As you've already heard, there are existing tools in the law that have been there for a long time and work better. If somebody calls the Social Security Administration and makes a true threat, why on earth would we leave this person in the community? Oh, hey, you signed a paper saying you gave us all their guns. I guess we can trust you now. Wink, wink, nudge, nudge. Everything's fine now. Why on earth would we leave that person in the community? This gives a false sense of hope because it is absolutely a horrible fit to the It is a horrible fit to the problem it has been put forward to supposedly solve. If you are indeed a threat, you need to be dealt with right now, not later. And if you are not a threat, why do we have this incredibly low standard that strips not just your rights, but the rights of those around you? Let's say hypothetically that my wife says something on social media and the officers in our area petition for an order against her, and they come and take my firearms. Where's my opportunity for a hearing? Forget before they come and take my firearms. I'm not the subject of an order. Nothing in the law whatsoever says that I have a right to a hearing. My wife might at some point. I never do, before or afterwards. That was there in the beginning. It has worked that way throughout this entire time. And don't get me wrong, do not dismiss these examples that you are going to hear about today as one-offs or whoops, something happened wrong. This law is working exactly as it was intended to work. And to be very clear, those are not my words. Bridge, Michigan, February of this year. It looks to me like it's working exactly the way we intended. State Representative Kelly Breen. Senator McMorrow sponsored the legislation, February of this year. Clear evidence that the law is working exactly as intended. And this is after these examples already came to light. Examples of 6-year-olds being subject to these orders, and then they go take everything from the parents. This isn't just a Second Amendment issue. I'm not here today just on behalf of gun owners. I'm here today on behalf of every citizen in the state because you don't have to own a gun to have one of these orders against you. The legislation specifically says so. Everyone, every breathing person in this state is subject to having their rights violated by this order. Everyone, not just their Second Amendment rights, their First Amendment rights. Post something on social media that isn't a true threat can be used against you. Your Fourth Amendment rights. The standard in here, the standard that was written by the former committee chair in this very committee, what I call the might-maybe standard. Let's do that weird thing and actually go to the actual language of the law. MCL 691.1807, sub 1. The court determines by the preponderance of the evidence that the respondent can reasonably be expected. I'm an attorney. I handle evidentiary standards. Evidentiary standards are meant to show that something is true or not. Is it true by preponderance of the evidence? Is it true beyond a reasonable doubt? You will do something by the standard. You did something by the standard. That's not what's going on here. It's preponderance of the evidence, okay, but that the respondent can reasonably be expected? So this is like reasonable suspicion, which is already the lowest evidentiary standard in the state, but it's not even reasonable suspicion, it's preponderance of the evidence that you might have reasonable suspicion. This is nonsense. Nonsense, and that's why we see so many of these issued on an ex parte basis. This is not communities protecting their loved ones as it was sold to be. That was an absolute lie. The vast majority of petitioners for these are not people petitioning for them against people they know. It is law enforcement petitioning against people in their community without personal knowledge. I want to be very clear about that. Oftentimes an officer will respond, another one in the department will fill out the petition for an ERPRO. How do they get this? How do they even meet the standard they have to meet without personal knowledge? And according to data released by SCAO, over 90% of these, over 90%, are petitioned and granted on an ex parte basis, if not an immediate ex parte basis. We talked about ex parte here, but there's another thing in the law that's kind of this super ex parte. We can skip the whole paperwork process and do paperwork and due process. If an officer just calls the court, says a number of things, and that's it. You can get this immediate ex parte order. And then when you go to court, you finally get your day in court, you now have to show by preponderance of the evidence that you are no longer a threat. Listen to that language. Listen. You are no longer a threat. It's not, hey, did we get this right in the first place? It's, you're presumed to have been a threat. We're not going to talk about whether you were a threat or whether we got this right in the first place. This was, you now have to show us, you have to show us that you're no longer a threat. Fourth Amendment issues, because the standard to get one of these is less than probable cause. So you have to have probable cause to get into my house on a search warrant, but under these, because it's that maybe standards, that's maybe not even reasonable suspicion, you can get into my house with less than probable cause now to search my firearms. You have Fourth Amendment issues. 2015, the United States Supreme Court in Henderson held that even felons have a right to alienate their firearms, meaning they can't possess the firearms, but they can sell them. The law says that the court can order them to go to the police or an FFL. And how do people get those back? They can't alienate their property anymore. So this has now a Fifth Amendment issue in it as well, because people can't sell their property to, I don't know, pay for an attorney to go fight this stuff. Clear takings. You have other issues, 14th Amendment, even potentially 8th Amendment. I haven't even gotten to the Second Amendment stuff, folks. And again, this isn't about just gun owners. This can and absolutely has been applied to non-gun owners. It can affect any person in the state. And so what I would say is, to the proponents of the existing law, will you save this, save the law from itself, or will you allow it to collapse under its own weight? As these examples, horrible examples that you will continue hearing about by others, because I only have so much time, will you save the law from itself, or will you allow it to collapse under its own weight? Introduce legislation admitting you made a mistake and fixing some of these clear and obvious problems that we are showing today. Madam Chair, thank you for your time. I'm happy to answer any questions.
Rep. Breen.
Thank you, Madam Chair. I really do appreciate the diligence you've put into this. And honestly, I do believe there are ways to improve the laws that are currently on the books, but not repeal them. But as you are talking about these cases and the standards to be applied, these are civil proceedings. And in order for the ex parte hearing to proceed, though, are you aware, though, that it is clear and convincing evidence that must be presented in order for firearms to be temporarily confiscated for, again, as little as 2 weeks until a formal hearing is held?
Clear and convincing, Madam Representative, thank you for the question. Clear and convincing evidence of what per se? The standard, again, is
that somebody posed an imminent threat to themselves or others.
that is absolutely not what the law says, and that is not what you specifically put into the law as the former chair of this committee. Again, it is not that somebody poses a threat to themselves. Let me be clear, and this is a wonderful opportunity to bring this up, because I think it's where we have common ground. Be clear, not middle ground where we have to compromise to agree, common ground where we already agree. There are people that pose a serious, imminent threat to themselves or others. We should absolutely deal with them. That's what I started saying.
I'm so happy we found a point of agreement.
I love it. That's why I started saying this is not whether we handle these people, it's how. My point to you today, if you take anything home, it's that we are not dealing with those people under the law. Because the standard is so low, I'll read it again. Preponderance of the evidence, and
Clear and convincing for the ex parte hearing.
and that's exactly the correction I was going to make. Thank you. Preponderance of the evidence for normal, clear and convincing for ex parte, that the respondent can reasonably be expected.
And so the preponderance of the evidence, though, that is when both parties are in court, and by the way, more than 80% of the time, these are being brought by law enforcement and not by a domestic partner or somebody else. And there is about a 20% rejection rate. So I want to make sure that at least we're on the same page when it comes to when it's clear and convincing, preponderance, ex parte, and a full hearing.
I don't think we're on the same page, Madam Representative, because you asked me about an ex parte hearing, but then you said both parties are there. If it's ex parte, by definition, both parties are not there.
If it's ex parte, the standard is clear and convincing.
Correct. But it's clear and convincing of what? It's not clear and convincing that this person will do something, not clear and convincing that this person is a threat. It's clear and convincing that they might do something in the future. That's the problem here. You have this, again, might, maybe standard. Evidentiary standards, we can think about them as a percentage. Call beyond a reasonable doubt, at least 95% certainty that it's true. Call clear and convincing, at least 75% certainty that these are true. Call preponderance of the evidence, at least 51%. I know that's just making it easy, but that's what we're going to do here because this is quick. You apply that to something that, whether it is or not true, is it 51% likely that you did this, that this is true, that you will do this thing? That's not what's going on here. It's 51% likely that you 25% might do something.
Have you attended any of these hearings where this is happening?
I'm sorry, I didn't hear your question.
Have you attended any of the hearings where this is happening?
I have not attended these hearings because they're typically at least a 90% basis happening ex parte.
Have you reviewed any of the case files?
Absolutely.
I'm happy to hear that.
Then
wouldn't you agree, though, that with these ex parte hearings, there is certainly clear and convincing evidence that is presented that somebody poses an imminent threat to themselves or others?
No way, no how, in so many cases. And we didn't even get to the whole bit that I mentioned before of when you present evidence, an officer presents evidence, oftentimes, many times, frequently, they're not even presenting evidence that they have personal knowledge of. When somebody typically has to do something in court, they have to certify something that they have personal knowledge of. It can't be hearsay stuff. Should be if I know you, forgive me for just working with this, and I petition for an order against you, I'm going to have to certify that for reasons that I have personal knowledge of. When officers do these things, they oftentimes do not do so based on their own personal knowledge. An officer will respond, another officer will move for or will petition for an order. And again, these are vast majority of the times granted on an ex parte basis. Forget the whole hearing part. That is one issue. But when they're being issued on an ex parte basis to this very low standard, which if you take one thing from this law that will make it collapse on itself, it is that low standard that came from this committee. Again, even beyond that, it's the lack of personal knowledge of the officer asserting to it. You then have other things where these officers are oftentimes leaving out absolutely critical information. My friend, Mr. Greenblatt, will be giving you an atrocious case that gives you everything you're looking for to show exactly how this law is being used illegally against people, where they didn't even do something. Somebody else did something. They put the guy in jail. And after putting the guy in jail, they went and got ERPOs against the grandparents that called the police for help against the guy they put in jail. Come on.
I'm afraid we're going to have to disagree on what the evidence is presented and the
Okay,
standard of it.
we are going to go ahead and, Tom, we are going to call up with your, because you guys were kind of all scheduled together. Dean, yeah, he's not leaving the bench, or the table, sorry. But if we can have Dean Greenblatt come up, he was on the scheduled list. Sorry, I missed that earlier when I announced him. And also Casey Armitage, because you guys are all from the same group. So if you want to come up, Casey, as well, supporting the bill, that would be great. And then Rep. Wozniak has a question.
Yeah,
real
thank
quick.
you, Tom, for your testimony. Is there a certain level that a threat has to reach to provide probable cause for the officials to respond?
Which officials? The police or the courts or?
The police, the initial threat.
Well, for the police to initially respond, no, they can just be called out and they would respond to a call. If they're going to do things from there, they must have reasonable suspicion to do certain things or even probable cause at that time to do certain things. Like if they want to get into the house, they would have to have probable cause that there's evidence to get into the house, especially without a warrant, probable cause plus exigent circumstances. So again, when the police have to normally do things, they have to have certain levels. With these orders, especially that low, that maybe standard I keep telling you about, it's lower than the normal constitutional standards for all of these other rights.
So the standard to harm oneself or harm another, does it elevate when the words say gun or shoot are used?
Let me answer this question like this, Your Honor.
Thank you.
Representative.
You're out of order.
I'm used to being in court and train myself that way. Put yourself in the shoes of these judges. Do you want to be that judge that didn't order something and had something happen?
No.
Do we see why so many of these are being issued, especially with a very, very low standard, over 90% on an ex parte basis?
I guess my question's on the other end. Does the word gun or shoot or anything that's like that elevate that probable cause?
It shouldn't, but it absolutely does, typically with a standard person. Because when you say, well, I'm going to go run somebody over versus I'm going to go shoot somebody, society is trained that the latter is going to be treated much differently.
That's what I thought. Because I've heard of incidents where people will call and they'll state that I'm being threatened, and the officials respond saying, well, they're only words, and they won't respond. So that's the lower level, reasonable probability. Or whatever. Thank you.
All right, Dean, you have the floor. Thank
Thank you, Madam Chair, members of the committee, for this opportunity to support Representative Santa's bills 41, 38, 39, and 40. I sincerely appreciate the ability to discuss Michigan's Extreme Risk Protection Order Act because so many others, along with me, were denied that opportunity to address it 2 years ago during the hearings in 2023. I am an attorney. I do practice in the area of constitutional rights, and I have substantial experience representing clients in mental health hearings earlier in my career, hundreds and hundreds of those who petitions for involuntary hospitalization were filed. And I was a court-appointed attorney on those because in mental health hearings, the state is required, or the county, and it's a civil hearing as well, are required to provide counsel, something that is denied those who are subject to red flag orders. I do want to share the story of two clients who have been recently victimized by this misguided law. My clients are grandparents in their 80s and 90s who have a troubled 35-year-old grandson. My clients have no criminal history, they have no issues with mental health, and in fact, grandma owns no firearms. The same cannot be said for the grandson, however. He was involuntarily hospitalized 4 years ago for mental health issues and would be homeless after being released from jail after a conviction for a felony if it were not for the compassion of the grandparents. A grandfather owns several hunting rifles, but to prepare for his grandson's arrival, he placed all the firearms and all ammunition in gun safes, and those safes were stored behind a locked door in the home. Grandson simply had no access. Thereafter, the grandson moves into the home in March of this year. Because of the mental health issues and other issues, the relationship between the grandson and the grandparents was troublesome, and the grandparents eventually sought the grandson's eviction, a PPO, and finally filed a petition for involuntary hospitalization with the Wayne County Probate Court. That court issued an order to transport and examine the grandson on October of 23rd of this year, just a couple months ago. The local PD stopped by the grandparents' home but didn't seize the grandson. He refused to go. They let it go at that, and they left him in the home. After that period of time, the grandparents were locking themselves in their own bedroom. at night because they feared for their lives. The grandson cut off his tether that was ordered by the county, and the sheriff received notice that the tether was cut and attempted to reach the grandparents, but they didn't answer the call, so a welfare check was ordered. On October 29th, the local PD arrived at the grandparents' home. Grandma let them in, they were okay, and led them to the basement where the grandson was. But he had barricaded himself in the basement, and when the officers attempted to reach him, he fired a shot in their direction. The grandparents were removed from the home, and the SWAT team began an 11-hour standoff with the grandson. Eventually, he surrendered. All of the safes were emptied by the police of Grandpa's firearms. But that wasn't enough. The local PD filed for an ex parte ERPO against Grandpa and Grandma, claiming that they were a threat if they were able to purchase a firearm, even though the grandson was charged with 4 felonies and has, and still has, a $755,000 bond requirement. No one's posting his bond. He's not getting out, and he still has the petition for involuntary hospitalization that will need to be addressed. But somehow, the grandparents that have been determined by the court to be a threat in an ex parte hearing, even though they never threatened anyone. They have no criminal history. They have no mental health issues. Now the grandparents are forced to spend thousands of dollars. They're not provided an attorney under the law in an effort to seek to have their fundamental rights restored. This case illustrates something that is quite commonplace, and you'll hear more stories, and I have limited time. But this is fairly commonplace. This is what's going on with this current ERPO law, and I ask the committee to fix it. Do everything you can to fix it. I'd be happy to answer any questions, certainly about mental health hearings.
Thank you. Casey, would you like to speak?
Thank you, Madam Chair and members of the committee, for this opportunity to testify in support of repealing Michigan's red flag laws through House Bills 41, 38, 39, and 40. I am Casey Armitage, president of Michigan Open Carry, a mother of 3 young adult children and the wife of a combat veteran. So far, I've dedicated 10 years to advocating for our Second Amendment rights. Today, I'd like to highlight the flaws in our Extreme Risk Protection Orders, or ERPOs, by drawing a parallel to something that we all rely on, driving. Both firearms and vehicles are tools that, if misused, can cause harm to ourselves or others. But driving is a privilege regulated by the state, while owning firearms is a constitutionally protected right under the Second Amendment. If anything, we should expect more safeguards for gun owners, not fewer. Yet Michigan's ERPO laws offer less due process than our system for addressing unsafe drivers. Consider how Michigan handles concerns about dangerous driving. Anyone can submit Form OC-88, a request for driver evaluation, to the Secretary of State to report a potentially unsafe driver due to medical conditions, accidents, or observed impairments. This form initiates a review process where the driver is notified and scheduled for a re-examination, which could potentially include vision tests, written exams, or road skill evaluations, before any action is taken against their license. Importantly, the state also doesn't seize the vehicle itself. It only addresses the licensed privilege to operate on public roads, and only after giving the driver a fair chance to demonstrate their fitness. Now, imagine if we flip that script for drivers, mirroring our ERPO laws. Suppose we created extreme risk driving orders, where an accuser, say an ex-spouse or a disgruntled neighbor, could petition a court to immediately tow all vehicles from your household and suspend everyone's driving privileges based solely on their claim that one person, even another driver in the home or a minor who isn't licensed, might be a risk someday. No accident, no ticket, no prior notice, just an ex parte order granted in secret. Police arrive at your home, impounding every car, truck, or van for up to a year, leaving your entire family stranded, unable to provide your own transportation, having to rely on the untimely transportation services provided in your area. Only after the damage is done do you get a hearing, where the burden's on you to prove no one is dangerous. We'd call that an outrage, a blatant violation of due process, opening the door to malicious misuse by anyone with a vendetta. Criminals would just steal cars or drive unregistered ones anyway, while law-abiding families suffer. Yet that's exactly what ERPOs do for firearms. Secret seizures without due process, flipping innocent until proven guilty on its head, and potentially affecting entire households by removing all guns from the home, regardless of who owns them. Just like the hypothetical driving order seizes every vehicle and impacts all family members' mobility. ERPOs can strip away a household's means of self-defense based on an accusation against one person, leaving everyone vulnerable, preventing mom and dad from providing their own protection and forcing them to rely on the safety services provided in their area, with police response times averaging 10 minutes or more when seconds count. This overreach not only erodes individual rights, but punishes innocent family members, transforming a law intended for safety into one that creates division and hardship, all without the upfront safeguards we demand, even for a mere privilege like driving. If we afford more protections to a privilege like driving, including mandatory re-examinations before action, why are we stripping away due process for our constitutional right to bear arms? These red flag laws don't enhance safety. They undermine trust, invite misuse, and fail to tackle root causes like mental health. As a mom protecting her family and a veteran's wife honoring my husband's service to protect our God-given rights, I urge you, pass these bills to repeal these flawed laws and uphold our constitutional protections. Thank you.
Thank you. Rep. Harris.
Thank you, Madam Chair. And this is probably geared more towards the two attorneys that are on the bench. So, ERPOs, are these public record? Once they're filed, are they public record?
Both the orders and I believe the petitions are.
Even if the judge decides that they're not going to take action on it?
Is my understanding the answer is yes.
Okay. So I think there was a comment made earlier about, going another route and that if potentially affecting somebody's reputation. Do you think these could be a reputational issue? They get filed?
Absolutely, yes.
Okay. Thank you.
Thank you. We are going to move on to Zoom here. We have